All rise. Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. We're here today in Peloton's acquisition versus Taylor, and it's number 1 CV140497. Each side will have 20 minutes for argument and upon it. You may reserve any portion of that you wish for rebuttal, but you'll have to keep track of your own time. You have a clock at the podium. We're recording the argument on YouTube, so in a couple or 3 days, you'll be YouTube stars. Please identify yourselves for the recording when you begin. And we have read the briefs and conferenced the case, so we are familiar with the facts and the law. You can go straight to your argument. Counsel, you may begin.
Okay, my name is Robert Barlow on behalf of the appellants, which are Paula Roberto, who's the judgment debtor, and Kinetic Control, which is the garnishee in this case. May it please the court. My client, Paula Roberto, was confronted with a garnishment of her earnings and having no recollection of any prior litigation. First sought to obtain additional information from the other side, the judgment creditor, regarding the nature of the claims, hoping that if she could see a copy of the complaint that resulted in the default judgment, hopeful that there be other records that would make it easier to remember exactly what happened, and if in fact there was some liability, we would have been more than happy to try to settle the case.
Could I ask you a question on that, counsel? So, your client's not sure whether she got served? She has
no recollection of being served.
But it's not a case where she is certain she was not?
No.
Okay.
No, she has no recollection. Keep in mind, this was 7 years
I understand.
prior to the time when the judgment creditor decided to try to collect this sum. And at the original sum, the judgment, I think, was only about $600 or $700. So this was not a huge case. But she has no recollection, and I left it open, the possibility that maybe she was served. We just wanted to know what the nature of the claim was. If it was a credit card claim, that hopefully that would trigger some memories on her part, and then we'd be into settlement mode. But the other side, neither the lawyer or the client was able to produce any additional records other than the default judgment that was through transcript filed with the Superior Court, and an affidavit of renewal of judgment that was filed about 5 years later. Those are the only documents that the opposing counsel had and made available. So, and the judgment, default judgment itself, had no information regarding the nature of the claim. So, not being able to determine whether or not she was served at all, we decided at the time of the initial hearing in Superior Court, we objected to the garnishment proceeding on the basis that it was void due to lack of service. The Superior Court, correctly so, citing the Marquez case, said, I don't have jurisdiction to hear your motion to set aside the judgment. Court of Appeals has already ruled on that, and you have to go back to Justice Court where the case originated. And that's consistent with the Marquez case. So we went back to the Justice Court. The Justice Court said, unfortunately, we can't hear your case either because it's been more than 5 years. We never received any copy of the affidavit of judgment renewal. We've closed the case. We consider this case, this judgment, void, and we've destroyed all the files.
Have you investigated under what authority the Justice Court would destroy files that are only a few years old?
Well, the 5-year period for the life of a judgment had expired, and they didn't have the.
Yeah, but it's still a judicial record. I mean, it troubles me that records are getting destroyed after only 5 years.
Well,
I have shirts older than this case, and I'm not.
I think you're wearing one today.
Yeah, probably so. And so, did you investigate whether there is some administrative policy that's been approved by the Supreme Court or otherwise to justify such a quick destruction policy?
Well, there's not only the destruction issue, but there was also, they refused to hear the motion. For whatever reason, they decided this case is closed, we have no record of it, we don't consider the judgment still valid.
Well,
So we
I
can't hear your
understand.
motion. But let me answer to your question. I actually have a personal friend who's the justice of the peace down in Gila Bend, and he abides by the same rule. He says after 5 years, they destroy records. So whether that's an administrative formal policy or that's a policy of individual courts, I don't know. But this apparently isn't the only court where such a policy does exist. And I understand the reason for it, because if the judgment is not renewed, what's the point of continuing to hold on to these paper records?
Well, I mean, this isn't really a challenge to you because it would support your position, but I would think that the public has an interest in maintaining public records more than a few years as a matter of general principle.
And hopefully, I mean, that's something the court can address, because they should maintain for reasons that exist in this case. Why not just maintain the records for 10 years? Why have a policy that says you get rid of them after 5 years? You know, there is this urge to make copies of everything, to make digital copies of everything. Why not make digital copies of some of these, records that may be more than 5 years old before you destroy them? At least make a digital copy, or at least keep some of the more important documents like the affidavit of service signed by the process server. Save some documents in case something like this comes up, but apparently there is no policy in place that requires them to do this. So it is what it is. I don't necessarily agree with their policy, but that seems to be their policy, and it's evidenced by the documents that are in the record.
So is your position that the judgment was valid at some point, but is not valid any longer?
That the judgment was valid?
Yeah.
No, we don't know if the judgment.
Initially.
We don't know if there was proper service, and we were hoping to see evidence that there was service. We came up empty-handed because the lawyer for the judgment creditor, and the court that originated this case, none of them have the file, none of them have affidavits of the process server. So without that, and then the question is burden. Well, who has the burden of showing there's no service? Well, I would think if the judgment creditor does not have proof that someone was properly served, and my client testifies that she was not properly served, she has no recollection of her being properly served, I think the judgment debtor is going to win on that issue.
That seems important to me, the difference between I know I was not served as opposed to I have no recollection that I was served. Isn't there a difference there?
No, I think one is honest and one may not be honest. I think it's honest to say I don't remember being served. It's possible to say I have no recollection. I know I wasn't served. I mean, to say that as opposed to say I have no recollection of being served, I think one is more honest than the other. I don't know.
I don't think there's any criticism implied of the credibility of your client's position, but the question is one of burden. If your client has the burden to demonstrate that the judgment is void and can't say that she wasn't served, then no matter how laudable her honesty, isn't that a legal problem for her?
Well, the inability to find the documents. I think we go to the issue of what, and we'll get to that. The issue of whether or not the certificate, the affidavit of renewal should have been filed in the justice court. If that's the proper court and not just the superior court, if that's what the law is or should be, then the fact that it was not renewed itself would invalidate the judgment. You never get to the issue of whether or not she was served or not, because if there is a requirement to file the affidavit of renewal in the court that has the records that originated the case, and the J.C. Penney case suggests that. I think the J.C. Penney case got it wrong when it said that the Coconino Superior Court was the proper court as opposed to Maricopa County. But in that case, they didn't need to reach the issue of whether the Justice Court should be the proper court. They did say in their in dicta that the proper court should be the court where the files are maintained, where the records are, so that if you want to litigate the issue of proper service or not, you can go to the court that has records. Superior Court that receives a transcript judgment gets nothing. There are no records other than the default judgment.
It's a great theory if anybody maintained records, but I guess I come back to the fact that I'm troubled that these records haven't been maintained. I mean, did you make formal inquiry and have the Justice Court tell you that the records had been destroyed?
We received a document from the clerk of the Justice Court indicating the documents have been destroyed. That's in the record. I didn't feel any need to go beyond that.
No, I'm not suggesting you should have. I simply find the destruction troubling.
Right, but that's not the only basis for our position that my client should prevail here. The question of where you file the affidavit of renewal, I think, is an important issue. It should be clarified that you file it at no great expense to the judgment creditor. They could just as easily file it in the Justice Court and the Superior Court where there's a transcript judgment involved. File it in all courts where you've appeared and make sure that everybody's on notice that you're extending the judgment. And then you avoid this problem of destruction of records, whether it's proper or not. If they know that the judgment has been renewed, presumably they're not going to be destroying records. So I think that's important. Our case doesn't rely solely on the fact that we didn't get an opportunity to present our case to void the judgment. I think the judgment is void because the affidavit of renewal was not filed on a timely basis in all proper courts, as it should be.
Why would you bother to even file a transcript judgment in Superior Court then? If you have to go back and you have to keep going back to Justice Court and filing renewals in Justice Court, what's the point of filing a transcript judgment in Superior Court in the first place?
I believe there are, and I don't do collection work, okay, but I believe there are additional collection remedies available in Superior Court that are not available in Justice Court, and that's why, counsel for creditors typically will file a judgment, a transcript in the Superior Court.
But isn't there also an advantage in filing a judgment in Superior Court for Maricopa County rather than trying to fish around and find the particular Justice Court where the judgment was entered? It's just an easier process all around, isn't it?
Well, the judgment, the default judgment itself indicates the Justice Court where the course originated. It's not a difficult thing to find out where the course originated. The transcript judgment, I believe that's in the record as well, has the Justice Court name on the top. So that's not a difficult thing to do.
Did it change in this case?
There was a change in this place, and we found that out because we originally went to the court that was on the top of the judgment, found out that there had been a transfer to another Justice Court, but we found that was easy to determine just by asking the clerk at the court. So that's not an impediment. Again, the goal is you want to keep these judgments alive as long as possible. And it just as a matter of precaution, you'd think you would file these things everywhere.
Did your client have any of her own records regarding the debt, or did she request any records regarding the debt from the creditor?
We don't know what the nature of the debt is. All we know is that there's a judgment, there's a default judgment. We asked for the entire file regarding this case. I was particularly interested in the complaint, so I could find out, was this a credit card, was it a car accident, what was the nature of the underlying claim. They had no information.
On the judgment itself, you didn't have the name of the judgment creditor?
The judgment creditor's been 3 of them. It's been assigned twice, and it doesn't indicate what the nature of the claim is, whether it's contract or tort or.
But the caption, no matter how the judgment has been assigned, the caption of the case should contain the plaintiff's name, shouldn't it?
Well, it has the name, but that didn't provide me additional information regarding what the nature of the claim was.
Right, but I mean, if you owe a debt and you see the name of the creditor, one would think you might go back and take a look. Not you. Counsel, all I'm getting at is I don't think it's fair to say that your client had absolutely no idea what this was about. If there's a judgment with a creditor's name on it, she could certainly look up records or see if she had any records or ask for her if it's a credit card. I think you're almost portraying it like she just didn't have a clue as to what this debt was about. Is that
she,
fair?
She didn't. I don't believe the caption indicates that it was a credit card company that was suing. I'd have to look at it, but I don't believe that's the case.
So you're,
And counsel for the other side couldn't offer any information whatsoever. And they're the ones that prosecuted the underlying claim. So the two cases again, the Marquez case, which I think puts the Superior Court in a tough spot because they don't have the right to even entertain a motion to dismiss or to void a judgment due to lack of personal service. They have to send it back to the Justice Court. Justice Court in this case had really no choice but to say we can't do anything, so we go back to the Superior Court. Superior Court said, I'm sorry, I can't do anything unless it's void on its face, whatever that means. But the judgment on its face seemed perfectly okay. It didn't say there's a problem with this because the renewal affidavit was not filed timely in the Justice Court. So the Superior Court was probably all he had to work with was the Marquez case. He said, well, I'm going to go ahead and just go ahead and enter the garnishment order, and if you want to appeal it, go ahead and do so. So we had no choice but to come up here to get some clarification of what the law is. Really unfair. My client has no forum.
is your argument in terms of the burden of proof that the creditor bears the burden of proof when the records are destroyed under these circumstances?
I would think so. They have the opportunity to preserve those records by filing their affidavit or renewal. They did not.
Yeah, I mean, you're not arguing that generally they should have the burden of proof. That would fall on the party challenging the judgment. But in this instance, where the records are destroyed, your argument is due process requires that the burden be placed on the party that's most culpable?
Right, and I think the burden does shift. I think it shifts if the records are destroyed. Even though they physically didn't destroy them, they had the ability to avoid the destruction of evidence simply by filing their affidavit with the Justice Court. And they, for whatever reason, they didn't do that.
And that's an interesting argument as it goes to the potential voidness of the judgment. But I'm looking at 1216.12a, and I'm just not seeing how you get to an obligation to file the renewal anywhere but Superior Court once there is a transcript of judgment filed in the Superior Court. If you maybe you can walk me through it and tell me how you get there. But looking at the language of the statute, it seems that either the United States District Court or the Superior Court is the place where the affidavit has to be filed.
Well, I think it just says at the end it has to be filed in the proper court.
Yeah, but it's talking about the District Court or the Superior Court, and it's not hard to figure out the proper court when you're talking about federal and state systems. There's no reference in the statute to filing that would suggest that they're thinking about filing anywhere but District or Superior Court.
Well, it says the renewal, it says a judgment for the payment of money that has been entered and docketed in the civil docket or civil order book of the U.S. District Court or Superior Court, which is the case here.
Right.
I'm not saying it hasn't, because there was a transcript judgment that was filed at Superior Court, and then it says whether originally rendered by it or entered upon a transcript of judgment from another court. So it contemplates that there was another court, in this case the Justice Court, that had the original case and it was transferred up to the Superior Court. It does address it. Or it says, or recorded with kind of may be renewed by filing an affidavit for renewal with the clerk of the proper court. And the proper court, what constitutes proper court was addressed in the J.C. Penney case, where it refers to, I think their conclusion was wrong, but their analysis was correct. It said the proper court is the court where the records are maintained, which is particularly germane to our case. Where the records are maintained is the Justice Court, which would presumably have the affidavit of the process server, would have the entire case file, so we can see that the default judgment was entered properly. So unless there's some questions that perhaps can wait, I'd like to reserve the rest of my time for rebuttal.
Yes, counsel, please.
Thank you. Do I need to reset this? Or?
No, sir. Counsel.
May it please the court, Rhett Fleming Bushman for Applee. Palisades Acquisition 16 LLC. Just like to start very quickly with the renewal of judgment. The J.C. Penney v. Lane case clearly indicates that the correct place to file a renewal of judgment that has been transcribed into Superior Court is in the Superior Court of that county. Specifically, the case says that the J.C. Penney judgment, which was obtained in Page, Arizona Justice Court, was rightly filed with the clerk of the Coconino County Superior Court, where it was entered in the appropriate records and became a judgment of the Coconino County Superior Court. And then shortly after that, in the conclusion, this court states, we conclude that the statutory requirement of filing in the proper court pursuant to the judgment renewal statutes means that if the judgment was a Coconino County Superior Court judgment, the affidavit of renewal was not effective unless timely filed in the Coconino County Superior Court, rather than in Maricopa County. The case is clear. Once a judgment is transcribed to the Superior Court, that is where you need to renew it, and in that county.
Do you see a systemic bug lurking here, though? I mean, at this point, are you able to demonstrate that you're even garnishing the right person?
I believe the records underlying our case, yes, we believe that we do have the right person that we're garnishing.
Prove that.
That is not necessarily true, Your Honor.
Not necessarily true? You might be able to prove it?
The counsel for the appellant stated that we didn't have records, and that is not completely fair to us. For we have a copy of the summons and complaint. We have a copy of the entry of default that was filed with the court originally. We also have a copy of the default judgment filed with the Justice Court.
Have you provided a copy of the summons and complaint to your colleague?
I believe those were, well, obviously originally provided. They were served. The affidavit of service itself, we do not have a copy. What we do have
So you don't know if it was served?
Not necessarily true again, Your Honor, in all due respect.
Well, when I ask you about what you know or don't know, I mean, it's not really a question of shading. It's not necessarily true. You either know it or you don't.
No, yes, sir.
And so if you know that the complaint and summons were served, I'd love to know how you know that. It sounds to me like all you know for sure is that a summons was issued, right?
If I may, Your Honor, the law firm maintains its notes, and every time a service of process is done, the exact wording from the service of process is entered into those notes. It is not possible to edit or correct that once it's in there. And those notes for the law firm show that that was served.
By what means?
By means of personal service.
At what address?
At the address that we had listed on file at the time with the mother-in-law.
So upon whom was it served? The mother-in-law?
At the residence, yeah, the statutes require that...
suitable age and discretion.
Yes, at the place of residence. So we do have evidence in our files that service of process was done. In addition, our server also maintains records. They have a record of the affidavit that they filed, not a court-stamped copy, but an actual affidavit that was filed. So the records are there. The evidence is not the direct evidence that you would typically see in a case where you would just pull out your court-stamped affidavit of service and provide that. But the evidence is there.
What was the nature of the underlying complaint?
The nature of the underlying complaint is, I don't have those notes in front of me. I believe it was for a credit card suit. The underlying was the plaintiff in this case was a debt buyer. They purchased the debt from another party.
All right. I know this isn't your fault. You had nothing to do with destroying the Justice Court records, but does that concern you at all in this case as far as burden goes? In other words, if the records are destroyed and these judgments are just renewed in a court that doesn't have any substantive records, then these judgments can just be floating out there and traded around like commercial paper, but they don't represent actions of the court that can be evaluated on due process grounds, because but the Justice Court destroys the records.
No, I understand the argument, Your Honor. I'd like to address it. I noticed the question you asked to the appellant regarding what is the procedure for a document destruction in the Justice Court, and I did have an opportunity to look into that. So the first is based on statute, which is ARS 22-124, which concerns Justice Court standards for destruction of documents. And specifically, it requires that the Justice Courts follow the rules as prescribed by the Supreme Court. So if you track that down, the Supreme Court general rule on that is Rule 29, court records. And it requires the Justice Court in Rule 29D that the Justice Court shall be maintained and may be destroyed in accordance with the approved retention and disposition schedules and the rules regarding superior court records as applicable. So the Justice Court follows the rules of the superior courts as follows record court destruction.
I was a Superior Court judge in Maricopa County, and their records aren't destroyed after 5 years. This isn't your case, I understand. This is not your fault or your issue. I'm just asking for your help in understanding.
Right, but if,
but it strikes me as bizarre that after 5 years, all the records of a case would be destroyed, so that even though there is a live judgment out there that can be enforced, that judgment can no longer be challenged by virtue of the actions of the government. Isn't that systemically troubling?
It is, Your Honor, but that is why, well, first I'll backtrack. It says Rule 94 is what the Superior Court is subject to, and it says that the clerk shall maintain for public use an exact replica of a record after purging and a device reviewing it. So just to backtrack just for a second, the courts are required to, even after they purge and destroy, which I believe is Judicial Procedure 4-302 for justice courts, they're required to maintain some sort of electronic copy in a viewer. The assumption there would be like microfilm, microfiche. But jumping to your argument, the Marquez v. Lane directly talked about that. In Marquez v. Lane, the original complaint was that under Rule 60, they were seeking relief for excusable neglect. And the Superior Court on the transcribed judgment said, we can't review it for excusable neglect. We can review it for one thing only, and that's if the transcribed justice is void on its face. And of course, they have to refer to out-of-state law to get there, specifically Pennsylvania. If you track those cases back, the Pennsylvania case, which it quotes, is the Golit case. Field Enterprises Educational Court v. Golat from Pennsylvania in 1962. That also says the exact same thing, that striking off a judgment, the exception to the rule where the next court up can strike off the transcribed judgment is when it's void for want of jurisdiction. And it cites several cases there, one of which is Vichowski v. Butcher. That case there describes exactly what's meant by that, which is what I talk about in my brief, that it would be something that would be void ab initio, meaning the original court, did not have subject matter jurisdiction or personal jurisdiction. And that's supported by the McMaster Financial case, the Master Financial Inc. case v. McMaster, I'm sorry.
But all those rules would really not be terribly well grounded if there weren't records somewhere to allow the types of review that those cases contemplate.
I do agree, Your Honor. And here's what troubles me is that a transcribed judgment, as required by a superior court and as the justice courts require, means only a certified judgment. And that's all you need to get a T number in the superior court, nothing else. Where the word itself, transcription, would imply some sort of transcript, which would indicate what was underlying the judgment, at least in terms of dates and times. There's nothing there. That may be a fault of the courts. I'm not sure.
Well, it very well may be.
But in this case, the Superior Court judge has the authority to look into whether this judgment was void ab initio, i.e. Rule 64, 60C4, to determine, regardless of the time frame, whether or not it's void. In this case, he asked the question prior to the hearing, be prepared to discuss this. And then after the hearing, he said, I listened to the arguments and I reviewed the record, and I've determined that this judgment is valid on its face. So based on that record, it seems that the Superior Court judge did indeed have the opportunity to look and see if this judgment was void, and made the determination that because it wasn't void, he didn't have the authority to review it. Every other Rule 60C option would have to be taken up in the other court.
Forgive me if I misunderstand. Are you saying that the only issue in Superior Court is whether it's officially valid or void? Or can the parties go deeper than that?
Pursuant to Marquez v. Lane and those things, it's just if the judgment is valid on its face, not void for want of jurisdiction, facially valid, but that implies void for want of jurisdiction.
So, for example, if a justice court enters a judgment for $1 million, we could determine that that's void on its face. But a judgment that is based upon faulty service. And here I understand you've got a judgment debtor who candidly says she just doesn't know. But if you had a judgment debtor who could establish conclusively that she had not been served, she was serving the military when they served someone else, or in a coma and publication was used as the name of means of service, something like that, there would be no way to challenge that judgment under the rules that you're outlining, because the court destroys the records. And so the court that can properly review the question has no records to review.
The court does have the authority to delve into those issues. I don't understand.
But how would it do that? I mean, how can a judgment debtor satisfy her burden if she has truly never been served with the case, never heard of the case, doesn't know who the plaintiff is, and the court's destroyed the records? It seems to me that there are only two choices at that point. Either we say the court has made life difficult for you, we're sorry, there's just nothing you can do, but there is this piece of paper that says judgment and you're liable. Or there could be a rule that imposes the burden on the judgment creditor to come forward with the records that the judgment creditor should maintain to demonstrate that the judgment is not void. I can't think of any other two possibilities in that case. Can you?
I don't, and I don't believe that Marquez v. Lane stands for the proposition that the Superior Court judge could not hold an evidentiary hearing on whether or not it was void and request records from the plaintiff to establish.
Right, but then the question would be, I mean, normally I think the burden is on the debtor, on the judgment debtor to do this. The question is, when the court destroys the records, does that change the burden of proof, or is that simply an unfortunate wrong that the courts commit that makes the judgment debtor unable to vindicate her position?
Admittedly, it's a very difficult question, one that requires looking into how long ago was it. I know that there's no time limit on challenging a judgment as void for jurisdiction, but at a certain point, there's not going to be records. You get 50 years past, those records may have long since been destroyed, even though the judgment may have been renewed and renewed and renewed.
Would the debtor carry her burden if she came forward with an affidavit that said, I was not served, there's no records to contest that, and the judgment creditor had nothing to show that she was served? Would that meet her burden?
If what you're asking, if there would be a prima facie showing by the person challenging that the judgment was invalid, then I think once the prima facie burden is shown, then the burden would definitely have to switch to defend the judgment.
But saying I don't recollect that I was served is not enough to make that prima facie showing, correct?
That would be, I wouldn't truly consider that a showing at all. Just maybe I don't remember. Seems so shallow of a burden to overcome that it's not a burden at all. Did that answer your question, Your Honor?
Yes, thank you.
Any further
It
questions?
creates an interesting problem.
It certainly does, Your Honor. Any further questions?
No, thank you.
I'll concede any remaining time to the appellant.
Thank you.
There's been reference to what the judge may or may not have said during the proceeding. There is no transcript in the record. So please disregard anything that was said regarding what the judge may have said in the proceeding. It's not in the record. Secondly, I make an avowal today. I never received a copy of the summons and complaint, although it was requested on numerous occasions. That's why we needed to see the file in the Justice Court. Third, there's been a lot made of the fact that my client doesn't remember a negative. You're somehow, it's for evidentiary purposes or for burden purposes, you're saying if you don't remember not being served, you may still have the burden of showing that you weren't served.
Well,
And I think that's an impossible. I mean,
It's not necessarily impossible, though. I mean, for example, let's. I know none of this is in the record, but let's hypothesize that there was service made on a person of suitable age and discretion at your client's residence, and that person of suitable age and discretion never told your client about it. For that reason, she might legitimately not remember being served. It is provable that she was lawfully served.
Great.
And it doesn't therefore make, it doesn't do violence to the law to say that it's her burden still to show that she wasn't served, because the law does allow service without direct notice. We presume notice in some cases.
Right, and I think it's actually more honest. I made reference to this earlier. I think it's more honest to say I don't remember being served as to make take the positive position that I was not served, because she may not know if she was served or not, because she should have been served because somebody else was there at the time the service was made.
Well,
she can't say I was not served.
See, that's the beauty of records retention, because then she can look at the affidavit of service and go ask her mother-in-law.
Right, and we don't have that, and I don't care what the lawyers may have in their office, copies of affidavit, nothing signed by a process server. There's no signed, a copy of a signed affidavit of service from a process server. If there had been, they would have provided it to me, because it was one of those documents that I was asking for early on. And again, I made this point before, and I may go over just by a second or two, but this case doesn't rest alone on the destruction of records. The affidavit of renewal should have been submitted to the Justice Court to extend the 5 years. The 5 years is not in and of itself an automatic deadline for destruction of documents. That, coupled with the fact that the judgment was not renewed, causes them to destroy records. Because if the judgment's not renewed by operation of law, that judgment is void. So that's why they destroy it. The 5 years alone is not going to cause them to destroy. If it's properly renewed, they will not destroy. Any further?
Thank you,
Any further? Thank you.
We'll take this matter under advisement, and we'll stand adjourned, but we're